Yeah, hi. When we talk about Article 14 is said to be the backbone of the Indian constitutional architecture, since it talks about equity, and egalitarianness. There are two major concepts under Article 14, that is, equality before law and equal protection of law. Equality before law, which we have borrowed from the UK conventions, and equal protections of law, which we have borrowed from the USA jurisprudence or USA constitutional framework. It has been brought in the USA jurisprudence via the 5th Constitutional Amendment Act and 14th Constitutional Amendment Act. Now, if we are looking toward the important judgment under Article 14, the first important judgment is Anwar Ali Sarkar versus State of West Bengal. In this particular judgment of 1952, for the very first time, the Honorable Supreme Court had provided, उन्होंने सबसे पहले प्रोवाइड किया था द टेस्ट ऑफ रिजनेबल क्लासिफिकेशन कि यदि कोई प्रॉपर रीज़न है तो संविधान के मानदंड के तहत लोगों का क्लासिफिकेशन या वर्गीकरण किया जा सकता है. In this particular judgment, the Honorable Supreme Court had held that the law made by the legislature must not be arbitrary. Rather, it should have a rational nexus with the objective, and it is based on the intelligible differential. The second important judgment is E.P. Royappa versus State of Tamil Nadu, the judgment of 1974, in which the Supreme Court had said that equality is antithetical to the arbitrariness, and any democratic state should not become an arbitrary state, and it should not violate the Article 14. So that is very important with respect to E.P. Royappa. In many reservation-based cases, we use this particular judgment. Apart from this, when we talk about Article 14, one of the important judgment is Ajay Hasia versus Khalid Muzib of 1981, in which the Honorable Supreme Court applied Article 14 to the government-aided institution as well. After that, in 1992, we have Indira Sahani judgment, which talks about the equity. Okay, means reservation, affirmative actions to the people like OBC, etc. So when we talk about equal protection of law, means class-based reservation. So it getting its genesis from this Indira Sahni judgment of 1992. Then another famous judgment is M. Nagaraj judgment of 2006, in which the Supreme Court had talked about the constitutional validity of reservation for SC and ST in promotion, and held that state must prove the backwardness in a quantitative manner, and if there is an inadequacy, there